What if America's most widely owned rifle, the AR-15, was suddenly ruled to be outside the scope of Second Amendment protections? This isn't just a theoretical question anymore. Right now, this exact issue is sitting before the Supreme Court, waiting for a decision. The core question the justices must answer is straightforward. Does the Second Amendment protect the right of Americans to own AR-15s and similar rifles? Let's dive into what's happening with this crucial legal challenge and what it could mean going forward. Before we get into the details, I need you to do something really quick. Smash that like button right now if you care about protecting your Second Amendment rights. It only takes a second, and it makes a huge difference in getting this information out to more people who need it. Also, if you're not already subscribed to the channel, hit that subscribe button and turn on the notification bell so you don't miss any future updates on your rights. Trust me, you're going to want to stay informed about this stuff. The case making its way through the highest court in the land is called Vermont versus Cook County. In this legal battle, you've got individual citizens teaming up with advocacy groups like the Second Amendment Foundation to fight back against a Cook County ordinance that makes it illegal to sell, transfer, or even own what the county calls assault weapons. The ordinance is pretty sweeping in its scope. It specifically names over 100 different rifles that fall under this ban, including the AR-15 and AK-47, along with other similar platforms. But it doesn't stop there. The ban also targets rifles based on certain features. For example, if you have a semi-automatic centerfire rifle equipped with a pistol grip, a folding stock, or a muzzle brake, it could fall under this prohibition. The people bringing this lawsuit forward argue that this ban goes way beyond just regulating firearms. They say it actually outlaws some of the most commonly owned and popular rifles in the entire country, rifles that should be protected under the Second Amendment. According to them, this flies directly in the face of previous Supreme Court decisions in landmark cases like Heller and Bruin. The plaintiffs are trying to use recent comments made by Justice Kavanaugh to strengthen their argument. Last term, there was a case called Snope that involved a rifle ban, and the Supreme Court chose not to hear it. However, Justice Kavanaugh wrote a statement along with that denial. In his statement, he essentially said that the time is coming soon when the Supreme Court will need to address this type of rifle ban issue head-on. He suggested it might happen within a term or two. The people behind this current case are hoping their lawsuit will be the vehicle that allows the Supreme Court to make good on that indication. On the other side of this fight, you have Cook County and their legal team. They've filed arguments with the Supreme Court asking the justices to refuse to hear this case. Their reasoning includes claims that there's no split among the circuit courts on this issue, and they argue these are military-style weapons that don't deserve Second Amendment protection. Essentially, they want the Supreme Court to simply deny review and let the ban stand. Let's look at how this case actually made its way to the Supreme Court. Back in 2021, this lawsuit was filed in a federal district court in Chicago. The petitioners challenged the county's ban, claiming it violated the Second Amendment. Fast forward to 2024, and while this case was still working its way through the courts, the state of Illinois passed its own statewide ban on assault weapons and certain magazines. This state-level ban overlapped significantly with what Cook County had already put in place. The state law is officially called the Protection of Illinois Communities Act, though most people just refer to it by its acronym, PICA. Around the same time frame, the Seventh Circuit Court of Appeals decided another case called Bevis v. Naperville. In that ruling, they upheld Illinois' law and made the determination that AR-15s were too militaristic in nature to qualify as protected arms under the Constitution. The court ruled that firearms useful in military service could be banned by states or counties. When the district court judge looked at the Cook County case, they felt bound by what the Seventh Circuit had just said in Bevis. Because of that precedent, the district court issued a summary judgment that sided with Cook County. Then in 2025, right after the Supreme Court denied the Snope petition, the Seventh Circuit took up the Cook County case on appeal. They granted review and ultimately issued a ruling that upheld what the lower court had decided. The Seventh Circuit relied heavily on that Bevis ruling and treated AR-15s as basically civilian versions of N16 military rifles. Once again, they concluded that these rifles are too militaristic for civilian ownership and that counties and states have the authority to ban them. And that brings us to where we are now, with this case sitting before the Supreme Court. The petitioners are asking the Supreme Court to finally take a hard look at this issue and make a definitive ruling on whether Americans have the constitutional right to own AR-15s and similar semi-automatic rifles, and whether state bans on these firearms violate the Second Amendment. Their petition makes the argument that circuit courts across the country are split and deeply confused about how to properly apply the principles laid out in Heller and Bruin. Some courts acknowledge that AR-15s are arms, but say they can be banned anyway. Other circuit courts take the position that these rifles aren't really arms at all because they're militaristic weapons that don't meet the textual requirement for constitutional protection. The petitioners are asking the Supreme Court to clarify that all firearms, including semi-automatic rifles like the AR-15, qualify as arms under the Constitution and therefore receive Second Amendment protections. In their Supreme Court petition, the plaintiffs present surveys, production numbers, and sales data demonstrating that tens of millions of AR-15s are currently in circulation and in the hands of law-abiding citizens. This isn't just limited to Cook County or even Illinois. These rifles are owned nationwide. The petition emphasizes that these firearms are used for completely lawful purposes, including self-defense, target shooting, and hunting. The petitioners make a compelling logical argument. If the Second Amendment doesn't protect the most common and widely owned rifle in America, then by that same logic, no firearm would be protected by the Second Amendment at all. Cook County has now filed their response to this petition for Supreme Court review, and once again they're arguing that the court should deny review of this rifle ban case. They maintain there's no circuit split, these are militaristic weapons, and this particular case isn't the right one for the Supreme Court to use to examine this issue. Cook County presents three main reasons why they believe this case doesn't deserve the court's attention. First, they insist there is no circuit split. They point out that every federal appeals court that has examined and reviewed assault weapon bans and state restrictions on rifles has upheld these types of bans under the Bruin framework. This includes the First Circuit, Second Circuit, Fourth Circuit, and Seventh Circuit. Because all these courts have reached the same conclusion, Cook County argues there's a consensus among the circuits. They claim there's no national conflict that needs the Supreme Court to step in and resolve it. Second, Cook County argues this case is a bad vehicle for Supreme Court review because they claim the plaintiffs didn't follow proper court procedures in the lower courts. According to Cook County, the plaintiffs skipped the discovery process and failed to present any admissible evidence to support their claims that these rifles are protected arms. In other words, Cook County is saying the plaintiffs rushed this case in an attempt to get it before the Supreme Court quickly, and in doing so, they didn't properly develop the factual record and evidence that would be necessary for the Supreme Court to thoroughly examine this issue. Third, even setting aside those procedural arguments, Cook County maintains that the lower courts simply got it right on the merits. They argue that rifles like the AR-15 are dangerous and unusual, and they claim these firearms are so closely related to M16s and other military rifles that they fall outside the protections of the Second Amendment. In summary, Cook County's position is that this case has procedural defects, the legal issue is already settled among the circuit courts with no conflict, and it's just not the right case for the Supreme Court to use to revisit the entire rifle ban question. At its heart, this case is asking the Supreme Court to finally do what many people have been hoping for over multiple years now. It's asking them to take up a state rifle ban, to examine these county-level rifle bans, and to review these kinds of restrictions on rifles with the hope of striking them down. The implications of this case extend far beyond just Cook County. A Supreme Court decision here would impact other states across the country and would help ensure that all Americans nationwide have the ability to possess these commonly owned rifles. Up to this point, the Supreme Court has consistently avoided taking up cases involving rifle bans and magazine capacity restrictions. They've steered clear of these issues almost as if they were avoiding the plague. However, Justice Kavanaugh indicated that the Supreme Court has essentially promised to address this type of issue, possibly within a term or two. Now we're going to find out whether that promise was genuine or if it was just another empty assurance. The stakes in this case couldn't be higher for gun owners across America. The AR-15 platform has become synonymous with the modern sporting rifle. Millions of Americans own these firearms for a variety of completely legal purposes. Some people use them for home defense because they're effective, reliable, and easy to operate. Others enjoy recreational shooting at the range, where the AR-15's accuracy and modularity make it a favorite among enthusiasts. Hunters appreciate the platform for its versatility, especially when hunting various game animals. The rifle can be configured for different calibers and purposes, making it incredibly adaptable. The legal arguments on both sides reflect fundamentally different interpretations of what the Second Amendment protects and how courts should analyze gun regulations. The petitioners argue for a broad reading of the Second Amendment that encompasses commonly owned firearms used for lawful purposes. They point to the historical tradition of Americans owning military-style firearms and argue that the founders intended for citizens to have access to effective means of self-defense. Cook County and other jurisdictions defending these bans argue for a more restrictive interpretation. They emphasize public safety concerns and argue that certain weapons are simply too dangerous for civilian ownership, regardless of how common they become. This divide among the circuits creates real uncertainty for gun owners, manufacturers, and retailers. In some parts of the country, owning an AR-15 is perfectly legal and unremarkable. In other areas, the same rifle is banned and possession could result in criminal charges. This patchwork of different laws and regulations makes it difficult for people to understand their rights and responsibilities, especially if they travel across state lines or move to a different part of the country. The Supreme Court's decision in this case could establish clear guidelines for how lower courts should analyze bans on specific types of firearms. It could clarify whether commonly owned firearms automatically receive constitutional protection, or whether states have broad authority to restrict weapons they deem too dangerous. The ruling could also address how courts should weigh public safety arguments against individual rights claims. For years, Second Amendment advocates have argued that the lower courts have been resistant to fully implementing the Supreme Court's directives from cases like Heller and Bruin. They claim that some circuit courts have found creative ways to uphold gun restrictions despite Supreme Court precedent that should protect gun rights. These advocates see the need for the Supreme Court to provide additional clarity and to reinforce that the Second Amendment protects real rights, not just theoretical ones. On the other hand, gun safety advocates worry that an overly broad Supreme Court ruling could invalidate reasonable regulations designed to keep communities safe. They argue that states should have some flexibility to address gun violence in ways that make sense for their communities. They point to statistics about gun deaths and injuries and argue that certain restrictions on particularly dangerous weapons serve important public safety functions. The timeline for this case remains uncertain. The Supreme Court receives thousands of petitions each term, but only agrees to hear a small fraction of them. The justices will need to decide whether to grant certiorari and hear this case, or whether to deny review and leave the lower court's decision in place. If they decide to hear the case, it would likely be scheduled for oral arguments in the coming term, with the decision following several months later. If you found this information valuable, do me a favor and hit that like button right now. It helps get this critical information in front of more gun owners who need to know about these changes. And if you haven't subscribed yet, make sure you subscribe to the channel and turn on notifications so you never miss an update on your rights. Share this video with every gun owner you know because this information is too important to keep to yourself. Thanks for watching, and I'll see you in the next one.